It has never happened before in judicial history. One judgment of the Supreme Court of India has sealed the fate of over 9,000 writ petitions pending before various high courts in the country and involving over 90,000 notices in connection with reassessment proceedings initiated by the Income Tax Department. Yes, it was on 4th of May 2022 that the Supreme Court Division Bench comprising of Justice M.R. Shah and Justice Nagaratna delivered a landmark decision which will be remembered for a long time. The Supreme Court has passed an order exercising its powers under Section 142 of the Constitution of India and held that this will be applicable pan-India to all decisions, whether pending or in pipeline, and will encompass all similar proceedings lying at all different levels. This is indeed epoch-making. The backdrop of this entire scenario arose from the Finance Act 2021, amending the provisions of sections 147 to 151 relating to the reassessment proceedings under the Income Tax Act. The new provisions became effective from 1st of April 2021. However, on 31st March and 27th April, via two notifications, the CBDT extended the provisions under the old unamended law until 30th of June 2021, which gave rise to several notices during the period of April to June of 2021. The challenge that was raised against these notices before various high courts effectively contended that the Income Tax Department had issued notices under the old law during the regime of the new period effective from 1st April, and since the relevant procedural provisions had not been complied with, the notices should be struck down. Friends, let me explain this in a little more simple manner. Under the earlier provisions as effective until 31st March 2021, reassessment could be initiated for a period of 6 years, and the procedure was that the officer would issue a notice under section 148, in compliance of which the taxpayer would be required to file the income tax return and seek for the reasons for reopening, which would be supplied, against which the taxpayer could raise objections before the assessing officer and, if required, then challenge the order rejecting the objections in a petition before the high courts. And the law and procedure in this regard were well settled by a fairly old decision of the Supreme Court rendered in the case of GKN drive shafts. Under the amended law, the earlier period of 6 years got curtailed to 3 years, and in exceptional circumstances, the department was authorized to issue notices up to 10 years as well. But the crux of it is 6 years reduced to 3 years. Moreover, in the interest of simplification, rationalization, accountability and transparency, it was also provided that the assessing officer, before taking on hand the reassessment proceedings, would issue a notice under section 148 asking the taxpayer to explain as to why reassessment proceedings should not be initiated in his case and giving reasons for the same. So what used to follow later came up in the earlier phase under the new law effective from 1st April. And after the 148A notice was attended to by the taxpayer raising his objections, the officer could either drop the proceedings on the merits of the submissions of the taxpayer, or if they got to be rejected, he would issue a notice under section 148 and take up the proceedings for reassessment. Section 149 of the Income Tax Act deals with the period for limitation. And as I mentioned, under the unamended old law, the period was 6 years. Under the new law, it got curtailed to 3 years. Now what happened was, between the period 1st April to 30th June, in the light of the notification, in fact the Supreme Court has noted this aspect in its order, that because of these two notifications, the assessing officers, they took the bona fide view and belief that they were empowered to issue the same kind of 148 notice as they used to do earlier, and the notices under section 148A were not issued though the law had come into force. Several high courts held very clearly and categorically that not following the procedure of issuing notices under section 148A and initiating the reassessment proceedings was bad in law prima facie, and therefore to that extent the department's reassessment proceedings were not maintainable. The Supreme Court was requested by the department to take up all these petitions together out of turn, so that the fate of all these matters could be decided and disputes and litigation could be checked. In its speaking order, the Supreme Court most interestingly has noted that the department was technically not justified in not issuing the notices under section 148A, though they were issued during the period of 1st April to 30th of June. However, the Supreme Court, in the larger interests of the Exchequer, has also mentioned that such a procedural lapse cannot make the revenue suffer in a big way. They said that such a procedural lapse should have been condoned by the high courts, and high courts could have held that the procedure which was initiated for purposes of direct notice issued under section 148, they could have been treated as notices issued under section 148A. The procedural lapse and even the mistake of the department, which was caused bona fidely because of the assessing officers holding the view that the notifications empowered them to follow the old law, the court mentioned that this situation was required to be redressed. In this context, the Supreme Court has held that the notices under section 148, which were issued at that point of time, can be treated as notices under 148A, and merely on that technical count, the notices or the proceedings need not be declared as bad in law or quashed. The Supreme Court has held further that within 30 days of its decision, which was delivered on 4th of May, the assessing officers would, in all such cases, issue notices to the concerned taxpayers and inform them of the material or belief on the basis of which the proceedings were reopened. In other terms, whatever was required to be done under section 148A at that point of time can be repaired and redeemed now. So following this procedure of 30 days giving a notice under section 148A to the taxpayer, the Supreme Court said that the taxpayer would respond within a period of 2 weeks, and on the basis of the same, as per the new provisions, the notice under section 148 could be issued, or if the AO is satisfied on merits, the proceedings could be dropped. Now, does this mean that all petitions decided or pending before the High Courts, or all these 90,000 notices are salvaged and each and every case will be decided as if it was decided in favor of the department? This raises a very important question mark. Fortunately, this has also been answered by the Supreme Court in its own judgment, because it has, while taking note of all these new proceedings, it has stated that the provisions of section 148A were a game changer. It has also lauded the objectives for introduction of the new reassessment scheme. However, it has made it very clear that while the procedural lapse can be condoned, the substantive law in terms of, and making a clear reference, the court has in no unambiguous terms stated clearly that the rights of the taxpayer or the defenses available to him under the provisions of section 149 shall very much continue. So does this mean that merely because the procedural lapse has been condoned, the Supreme Court is giving a go-by to the substantive law in terms of the provisions of section 149? The answer is a clear no. Let me explain as to what notices will survive and what in any case will get quashed, even by the ratio as laid down by the Supreme Court itself. Take for example, a notice was issued during the period April to June 2021. Under the new law, such a notice could have been issued only within a period of 3 years from the end of the assessment year. So, if there was any assessment relating to assessment year 2017-18 or earlier years, and it is a well-known fact that because of the 6-year rule, the assessments for 15, 16, 16, 17, 17, 18 assessment years had also been opened. Because the Supreme Court has said very clearly that the defenses available under section 149 continue, and the substantive part of the new law also continues to take full effect, it would mean that any notices until assessment year 2017-18 unless they fall under the very special cases of 10 years, which is a separate matter altogether. Even the Supreme Court was not required to go in depth into that. So what would perhaps survive would be only notices for assessment year 2018-19 and thereafter. So frankly speaking, if this entire decision is taken, I think as taxpayers, as revenue, a very balanced view has been taken by the Supreme Court as it has struck balance between the revenue and the taxpayer. The notifications have not been upheld as valid. The Supreme Court has not even said anything as such about the validity of the notifications, but impliedly the Supreme Court has said that the notifications can only protect the revenue to the extent that the procedural lapse shall be rectified now on, and that too keeping in view the provisions of section 149. But let us be very clear that until 30th of June, those who held the view that the 6-year reopening rule under section 149 could have prevailed and could have validated the notices during that period, I think the Supreme Court has set even that controversy at rest. So, to sum up, the Supreme Court decision has very much, perhaps for the first time, with great concern for the public exchequer, the interests of the revenue, and the interests of the taxpayer. So, in this backdrop, this entire decision has to be viewed, and I think if we look at it from that point of view, this is going to be on record as a landmark historic decision in the excellence of tax jurisprudence.